unless it is contrary to the divine law.
No, Paul's letter to the Romans...
I just read back your words.
Yeah, no, Paul's letter to the Romans doesn't say that, Your Honour. That's what Gaudium Spes says.
I see.
Yeah, but it references Paul's letter to the Romans. Everyone is to obey the governing authority, and you must be obedient for your conscience sake. It's about there's bits in between. But that
you must be
obedient for your conscience sake. But there are bits...
What does that mean?
You have to, morally, you do the right thing.
So where do we end up if there's a conflict between canon law and the civil law?
Except if it's contrary to divine law, and it's obviously not contrary to divine law, to own the abuse of children for what it is, and to report it to the appropriate authorities.
When you say divine law, you mean canon law?
No. I mean the law as we understand it from God. The Ten Commandments, for example. No, not this. The law as it comes from God, which we will find in the Scriptures and in documents like the Ten Commandments.
Right. So we are to understand there's a set of laws, if you like, which are divine, and then there's canon law. What's the relationship between the two?
Canon law actually looks at specific situations in relation to the church, its governance, etc., and spells that out in detail. There are many other laws beside the Code of Canon Law. There are books with liturgical laws. My own lifestyle, Your Honour, is governed by a set of laws that are not sitting here in canon law. This is not the only law in the church. Dioceses enact laws that apply to that particular diocese.
Well, leaving aside divine law, if there's a conflict between the civil law and any other law of the church, canon law or whatever, which prevails?
My practice would indicate that in relation to the abuse of children, civil law must be followed.
But what about otherwise? What about other issues?
I can't think of one, to be honest with you. What would be an example?
I don't know what you know about the church law.
Oh, right.
Mr. Friedman, perhaps I give an example that might make it clearer.
Certainly.
If we look at the law, canon law, the laws that are in the Code of Canon Law, and we go to the sacrament of marriage, for example.
Yes, that's right.
The teaching of the Church is that marriage is indissoluble. Therefore, if a couple get married in the Catholic Church and that marriage fails and there's a divorce, they are free in our civil law to remarry. They are not free to remarry in the Catholic Church. It's more a conflict about teaching, whether the teaching is reflected in the law. Another example is, as I understand the regulation...
Sorry, you'll need to speak up. They can't hear you at the back.
As I understand the Marriage Act, first cousins can get married according to our civil law. There is the impediment in canon law about first cousins getting married, for which they can get a dispensation. So if you look at it just in theory, there is a conflict because in one system, first cousins could go and get married. In another system, there's a regulation that says you need to get a dispensation for that to happen. And another example would be a spouse, a woman whose husband has died, marrying her brother-in-law. So I understand that our civil law doesn't prohibit that from taking place, but there is that regulation. So they're simple examples, but when Professor John Hughes talks about that, that was they're the sort of practical examples that we have. But Canon 22, there's no application of the distinction in canon law between a narrow or a strict interpretation and a broad one. There's only three lots of laws in the canon law that have to have a narrow or strict interpretation, which are laws that impose a penalty, laws that restrict a free exercise of rights, and laws that are in fact an exception to an established law. So the interpretation has to be, what is the context of the law? What does the law say? And the context of 22 is very clear. It's about the church having to make laws because it has to make it for its community, and whether or not in a particular instance it will use the laws that are in place in the state and say those laws we will abide by. The code has some 36 references to the civil law in the canons, but those are not incorporated. They talk about canonising the civil law, which is a totally inaccurate phrase in one sense, but the other ones do not talk about any conflict. They simply say, like for example, the law would say that whatever the civil law says about the adoption of a child, if a child in the civil law is recognised as adopted, that is what the canon law means when it uses the word adoption.
Dr. Austin, the impression I have from what you've said is that the canon law or other laws of the church may impose a greater restriction on a person's personal or legal capacity.
That's correct, Your Honour.
Than the civil law, and in that way there will be a conflict.
Yes.
But the conflict is one way. Is that what you're saying?
That is correct. And in regard to the example I gave about marriage, it's resolved, if you like, by a dispensation being given.
Yeah. Mr. Tapsell, do you want to comment on that?
Well, the only comment I'd like to make is that the rules about restriction on marriage are written in canon law. So that it's written in canon law. It doesn't come from the Gospels. It doesn't come from anywhere else. It's written in canon law. And that's all the point I was trying to make, is that there is a strict division between what's in law and papal encyclicals, church doctrines, catechisms. What Sister Hannon's trying to say is that all these things are somehow laws, but they're not. Laws have to be promulgated in some way to become laws, as I said. Otherwise, adultery is a canonical crime, and it's not.
I might return a little later to this topic of conflict when I ask you some questions about the nature of reporting obligations. But if I could ask you to address a slightly different topic first. And this is really by way of introduction to your view about the role that canon law played, if any, in impeding the Church from responding appropriately to allegations of child sexual abuse. And I just ask you to briefly outline your views on this topic and respond to a couple of comments that have been made in submissions to the Royal Commission. Baroness Hollands, who is a member of the Pontifical Commission for the Protection of Minors, has stated in her submission that the 1983 Code has been, quote, ill-equipped to deal with cases of child abuse. And Professor Parkinson, who some of you may have heard give evidence yesterday, has said in his submission that canon law is woefully deficient as a means of addressing child sexual abuse and remains so, notwithstanding that the limitation period has now been extended to 20 years after reaching adulthood. So perhaps, Dr. Doyle, if I could begin with you, to just give us your response to those submissions.
First, I would agree with both of those submissions. My own opinion, based on my experience, is that canon law has been used as an excuse in some instances by ecclesiastical authorities for not proceeding in taking direct action against reports of sexual abuse. It has been used as an excuse for not reporting to civil authorities, and it has been used as an excuse for allowing accused clerics to continue in ministry. Contrary to those excuses, it is possible to look into the canon laws, the code, the laws that are in the code, and find instances that did empower a bishop to do something significant when he received a report. Now, that's one side. The other side is the reality. Now, I can't speak directly from my experience in Australia, but I can from the United States. excuse me, the United Kingdom, Ireland, Belgium, and I believe Mexico, places where I've been involved. And the reality there is, in spite of what the canons have said or provide for bishops, in many instances they're completely bypassed. And the action that is taken is something that, whether it's contrary or not to canon law, really doesn't seem to have mattered much. But the rule or the norm that was governing this action was expediency with regard to protecting the image of the institution. In reality, the code, unfortunately, is, as I've said, and as Dr. Furness mentioned, it's a legal system that is in service to a hierarchical or monarchical government. I don't think anyone has mentioned yet the fact that in the institutional Catholic Church, the office of Pope and the office of diocesan bishop, in those offices, the three common functions of government, which are judicial, executive, and legislative, are combined in one person. Consequently, there are no checks and balances, and it is not, it's much easier for an ecclesiastical person, an ecclesiastical authority, to act contrary or outside of the norms of law, and there will be no way to rein that person in. No appellate process that could be effectively used.
When you speak of canon law being used as an excuse for inaction, are there features of the canon law that have made that possible in your view, or is it entirely a question of poor administration of the law?
I think there are, the answer to that is in three parts. One is those who simply, doesn't matter what the law says or doesn't say, they will take an action such as simply removing a priest secretly and sending him to another parish secretly. That's clearly outside of canon law, because you're dealing with a man who is suspected or known to have committed crimes that put children at great risk. That's number one. Number two, as far as the law itself is concerned, one of the things that has come up, and this is after the new millennium, when, or maybe in the late 90s up till the present, when this issue rose into the public forum, and people knew what had been going on. So one of the excuses that was offered, well, we couldn't act because we were bound by secrecy. Simply a broad statement like that. And I think you would be hard-pressed to find a chancery office when reports came in where the bishop and his staff engaged in a discussion or a debate as we have been doing here over the meaning of the law. There may have been some that did that, none in my own experience. So that's one issue where the issue of secrecy, rightly or wrongly understood, was used. Secondly, the provisions that were possible were simply not used. And a third issue is the awareness that some have had that in the canonical criminal process, imputability or responsibility for the crime committed could be reduced if the individual acted under the force of some form of mental illness or in the heat of passion. And that has been used as an excuse because pedophilia is considered to be a psychosexual disorder listed in the Diagnostic Statistical Manual of Mental Disorders, which is published in the United States, and in some countries, English-speaking countries, used in general to enumerate these issues. So when you have that, that means you can try a man, but the penalty, the ultimate penalty cannot be imposed, which is dismissal from the clerical state or defrocking in secular terms.
Just having raised that topic of imputability, does canon law deal with any other consequences for a person who's engaged in conduct that might be wrongful but they have some disorder? You'd be aware in the criminal law, for instance, in the civil law systems, a person, if found insane, might be committed to an institution rather than convicted.
Well,
is there some equivalent in canon law?
The church no longer can commit priests to their own confinement facilities, their own jails. They could at one time. However, in the code, the canon that speaks of sexual abuse of children, of minors, which in the new code is 1395.2, lists as possible penalties to be imposed a number up to and including dismissal from the clerical state. But that is not the one, that is not mandatory. Another is suspension, removal from office, and so on. And in some instances, we have seen over the past few years when men have been dismissed or have been tried by an administrative process by the Holy See, they've been sentenced to what is called a life of prayer and penance and removed from active ministry. That's usually done when the man is quite old or suffering from some infirmity that would render him incapable of taking care of himself in any way when he's out, if he's dismissed outright.
But what about if you're found not to have breached the canon because the conduct is not imputable?
If the conduct is not imputable and he's subjected to an ecclesiastical trial, then it would be up to the judges. If they found that he was not imputable, they could acquit him, or rather than acquit, in canon law, they would say that there is not enough evidence to convict. Not that he's innocent, but we don't have enough evidence to convict him on this particular charge.
And canon law doesn't then impose any consequence? No,
I mean, if he's exonerated, if there's no evidence of wrongdoing, if there's not acceptable evidence of wrongdoing, let's say, then there are no consequences.
Sister Hanlon, if I could turn to you and just coming back to that general question I asked, I understand from your submission that based on your own experience with canon law, you haven't found it to be an impediment to dealing with allegations of child sexual abuse. Is that accurate?
That is accurate, Mr. Free. My experience is very limited. I have not been in this field very long at all. And that has been my experience, that if the law has been applied well and procedurally, and if the substance is there, the result that was required is got. I know with the Nesta case, in dealing with the CDF, the Congregation for the Doctrine of the Faith, there has never been any document from the Office of the Bishop in Wollongong there for more than a couple of months. In the Nesta case, which was quite different, that had begun with an appeal to the Congregation for the Clergy and appeals against that, and then went to the Apostolic Signatura. Now, that was with the Signatura for 5 years. I find that quite inexcusable and indefensible. But it was only with the CDF for less than 2 months when it came back that invite the priest to apply for laicization or he will be dismissed. There was another case where we did what in actual fact you're not exactly invited to do. You're invited to put the document to the CDF and ask their opinion on how you proceed. But in this particular case, the man was very elderly. He had dementia, and we saw it as an injustice if he were dismissed, because he would then become the responsibility of his nieces and nephews. And we just saw that as not right. So we asked that he be put under penal precept, that he be unable to use the title or wear any insignia of a priest, and obviously to practice any ministry, that he would be in a high security dwelling of the bishop's choosing. And that was granted. A high security aged care facility into which he was placed was very modest, with shared accommodation, nothing lavish. But it was more a consideration for his family as against himself that we asked that he not be dismissed.
When you're referring there to asking, are you talking about asking the congregation?
Yes.
The Doctrine of the Faith?
Yes. Now, I have also found in dealing with the congregation in several of the cases with which I have dealt with them, the statute of limitation had long expired. And in each case with the case, we requested the congregation to disregard that, and in each case they did.
Sister, why couldn't that person have been dismissed but the church continued to have cared for him in a aged person's facility?
Because when the person is dismissed, Your Honour, the church has really got no authority over him. He's a free person. So all he really retained was the fact, as far as anybody in the public arena was concerned, that he used to be a priest. He didn't seem like one. He couldn't use the title father. He was not referred to as father. I have to say that when approaching the aged care facility, we told them up front. They knew exactly the situation. We weren't trying to disguise anything. So it wasn't and he was under penal precept. He had no freedom.
Dr. Doyle, I gather you have a comment to make, and can I ask you perhaps just as you do it, can you address in particular the proposition that the Royal Commission has heard from various witnesses in various case studies that there has been a problem with the timeliness of these processes, particularly in Rome?
That I would totally agree with that. The short comment I wish to make is that objectively, the canons in the code provide what would be necessary and effective to deal with the issue of sexual abuse of children by clerics, if they were properly applied in an equitable, intelligent manner. The problem is that has not been done. I personally would separate the consideration of this, and I think a good example is what Sister Moya has been talking about, a situation where the law has been used on the local level effectively, but then encountered at the top level totally unacceptable delays for reasons that are never revealed. Prior to the widespread public knowledge of sexual abuse by clerics, which began in the middle 80s in the United States, and I know it was known in Australia by the end of the 80s because I was asked to come over here in 89 and address the issue at a canon law convention. Prior to that era, there's very little evidence that I have seen that the proper use of the code of canon law and the available canons under the old code, they were very, 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 very rarely used. And so that what you had there is a wholesale negligence and abuse of what could have been done for other reasons than protecting due process or protecting the rights of those who had been violated and those who had been accused.
Thank you. Dr. Austin, what's your position on this general overview of the role of canon law?
Mr. Freething, I think Father Tom the other day explained that they wanted to put something to the Bishops' Conference, a manual of how to deal with this, and the response was
Ignore
it. In Australia, Bishop Jeffrey Robinson has told the Royal Commission that the document of 1962 was unknown to him until the late 90s. If Bishop Jeff didn't know about it, I think the Royal Commission can safely assume that neither did any other bishop. If they didn't know about the procedures in that, then clearly, at least from 83, but also under the 1917 Code, as Brother Thomas just said, there was a procedure to be followed. What has been happening is that the focus of the conversation has been about penalties and penalising people and punishment. The example that Father Tom gave, that a case may have come where it was found that the person had not committed a crime for some reason. In a sense, that's not the end of the story, or indeed the real issue. The real issue is that some priest has violated or sexually violated a child, and no bishop or no authority in the church can say, well, we didn't get a conviction in the tribunal, therefore there is nothing to be done. Quite the contrary. There is something to be done, and that's an obligation in justice to the victims But I don't see that surfacing in the conversation, where the conversation is driven towards a legal, sort of a legalistic approach in that context. So my concern is, and if bishops did not follow the procedures in the Code of Canon Law, either under the 17 or 83, I don't believe the law that we had was a conspiracy to anything. They just did not do it. And I think Father Thomas' example the other day sort of speaks volumes. Why didn't they do it? Well, I think we've heard that they didn't want to face up. They didn't want to acknowledge it. Some would have been paralysed by what to do. I have to say, from my point of view as a canon lawyer, very often canon lawyers were not asked advice. Your Honour, could I mention an example that concerns yourself? It was in the John Ellis case, where the way in which the whole case was handled, I think you said at the end of the Archbishop Cardinal Hill, the way it was dealt, you said it wasn't very Christian.
They were his words, actually.
Yes, and he agreed. I would add to that, if he had been advised by a canon lawyer, if he had known canon law, the law says quite clearly, in keeping with the scriptural responsibilities of reconciliation, any dispute should be attempted to be resolved with due regard for justice without having to have it dealt with in litigation. But above all, bishops have that responsibility. So I do not know why, in the case of John Ellis, which, as you know, is an expert witness for that case, why did it come to a point where a victim of sexual abuse had to go through that process when canon law clearly said if John Ellis has to, for the reasons of the civil law, put in a claim because of the statute of limitation, why did civil lawyers say, well, that's happened, we can't continue mediation? That is a complete violation of gospel teaching and indeed of canon law. I do not understand why that's happened. But, you know, it did. So.
Thank you, Doctor. Mr. Tapsell, can I turn to you? And I understand you have a different view about features of the canon law that have contributed to the problem of the church response.
Yes, because the problem is, and every bishop that I've seen come before this commission, including Archbishop Coleridge, who was here yesterday, said it was extremely difficult, if not impossible, to dismiss a priest. Now, when you actually look at the canon law, up until 2001, there was a 5-year limitation period. That meant that unless if a child was 10, was sexually abused, if they did not complain to the church by the age of 15, the canonical crime which would allow for dismissal disappeared. The Catholic bishops did a survey in 2000 as to how many cases, and they examined 400 of them, how many of them were outside the limitation period. Well, put it the other way, how many were inside? 3.2% of all those cases. They could not be dismissed. Now, I agree with what my friends say. That doesn't mean that nothing could be done. They could have their faculties removed, for example. But that was not a permanent thing. And so you had people in Melbourne and so forth, also Nesta, appealing to the congregation, you can't take away my faculties permanently. It's a permanent punishment. The comment that Justice McClellan mentioned, I think, is quite pertinent. You have these victims who have had their lives ruined, and then when it goes up before the CDF, and there is then a possibility of dismissing them, and they say, oh no, well, you won't be able to call yourself a priest, etc., etc. Wouldn't you think that the church's maximum punishment, dismissal, would be imposed? Now, the point that Sister Hanlon makes is a good one. Okay, if they're old and so forth, the church runs lots of old people's homes. If this man's in trouble, he doesn't have to be looked after by his nieces or nephews. The church can look after him. The point that she makes is that if he's not dismissed, the canon law requires the church to look after him. But if he is dismissed, they can still look after him, just like they do with lots of people who aren't even priests.
How do you control him?
Just on the topic of limitations periods.
I think Sister wants to respond to that.
I'm sorry, Sister.
Yes, Mr. Free, look, once a priest is dismissed, technically the church has no authority. We may be able to say to him, we have this aged care facility and we would like you to go there. If he says no, that's it. And in this case, the priest concerned was not from the state of New South Wales. We had no way. So I accept that, I believe that if these crimes are committed, it is shocking and they really demand the greatest punishment. But I think there are always some exceptions that actually are for the good of a community, not for the good of that person. It was not a nice place where he was. I can assure you of that. I would not have liked to be there myself. That's true.
Dr. Doyle, I think you had something to add.
I'd just like to make a comment and follow on what Sister Moya said. Laicization is the ultimate punishment for a priest. I mean, there's one other one, which is excommunication, and that has not been applied. But apart from the legality of it, one of the issues that has come up significantly in the United States and Ireland to some extent is this. If we laicize some of these men who are predators, sexual predators, we will have no authority over them and no way to control what they're doing. And so for the sake of the safety of the community, some have urged, and I'm one of them, that they not in fact be laicized, but they be placed in a situation such as she described, where there is strict monitoring, where there is psychological assistance, and all of this for the good of the community so that these men will not be roaming around as if they were back out of prison where they had no care and could then go and molest other children. And the evidence of the possible validity of that argument has been the experience at the other side of the world, where a number of men who have been laicized and would disappear into the ether and then would reappear when there was a report they had been arrested because they had reoffended, and then the local bishop or the religious order is asked, why did you let them go?
Doctor, what power does the church have to restrain?
I beg your pardon, sir?
What power does the church have to restrain?
They have no power if the man is laicized.
No, if he's not laicized, what power does the church have to restrain his movement?
The only power they would have, for example, if he is still a priest, still in the clerical state, but has no faculties, nothing of that nature, would be, first one would be a moral power appealing to his, if there is anything left of his sense of right and wrong. But the other is practical, and that's if, we're going to take care of you, we're going to feed you and house you and give you medical care, we can cut all that off and you'll be destitute on the streets. That's the only other possibility.
That's the same if the man's laicized.
I beg your pardon, sir?
Why couldn't that be the same if the person is laicized? The church offers sustenance, will cut it off if the person doesn't obey the rules of the house or wherever they are.
If they don't obey the rules and they do, if they're laicized, there's no obligation.
I understand that.
Yeah.
But if the incentive, you say, the restraining capacity, when he's not been laicized, is the church will continue to provide sustenance, why couldn't the same prevail even when the person is laicized? Church provides sustenance on condition that you obey, the former priest obey the rules of the house.
You're totally correct. There is the answer to that, the question you're posing, Your Honor, I think, is that, in fact, that would be possible, because you'd have the same hammer over his head, so to speak. If you stay within the boundaries that we're setting up for you, we'll continue to take care of you. But as I said, one of the arguments that has come forward at home, at least, is that we have at least some connection if they're not laicized. And I guess my ultimate answer to that is take it on a case-by-case situation. But that is not being done. In fact, they're being laicized if a man is, unless he's old and infirm, they're being laicized and cut loose.
Yet in the religious institutions, both in Australia and elsewhere, a number of the male orders have retained within their orders and congregations those that have been convicted and released from jail. And that is not an uncommon phenomenon in the religious orders in Australia. What's your view about that?
That's a similar situation in other countries where their connection to the church and to the religious order is different than the connection of a diocesan priest to his diocese or his bishop. If he takes vows to a religious order, he's in a sense part of a family, and there's still an obligation to care for that man as long as he remains part of that family. And so what, practically speaking, a number of these men have gotten out, they've had nothing. They've had nothing in their pocket except what they got when they left the penitentiary. And so the order takes them back in. And some places, some religious orders have had very capable, very responsible programs to keep an eye on these men, where they in fact are back in confinement, only there's a cross on the wall. In others, one instance that I know of, unfortunately, the men who have been brought back to the religious order are each given a credit card, and they're given access to automobiles, and there's no supervision, and there's no questions asked. And one priest in this particular environment, this particular religious community, challenged this to the superior, and he was removed from the community.
But in some of the communities, if I can just ask this, some of them retain the title of brother, for example, and others have removed the title of brother, and to the external world, in the first case, they remain a vowed brother. Is there anything in canon law or anywhere else that guides religious orders as to how to deal with those circumstances? Sister, you mentioned that the priest was not allowed to be called father. He removed.
That's correct.
But in some of the religious orders, that's the case. In other religious orders, that's not the case. Is there any guidance by the church at large to religious orders of priests or brothers, or nuns indeed, that guides how one should respond to those sorts of circumstances?
None that I know of, Your Honour, none.
And why is that, given this is an issue that's been confronting religious institutes for the last at least 20 years?
The only honest answer I can give to that is irresponsibility, and in many instances an inability or an unwillingness to face the grave situation and the grave reality of what we're dealing with.
Well, then the next question is, what should be done about that?
What should be done, my feeling is what should be done is there should be, since we are a hierarchical, monarchical system, something from the top giving orders to the religious institutes on how to deal with some uniformity dealing with this issue, but there has not been anything that effective. It's very difficult unless you have, on the part of the superiors, a very serious sense of responsibility about this particular issue.
Or a law.
Pardon, sir?
Or a law.
Or a law. A law would be very nice, and I'm not saying that facetiously. It would be certainly helpful in the institutional overall picture of the Catholic Church to have some form of legislation with teeth in it. For example, to the bishops, if you do not conform to this, you will be removed, and you will not have the ability to fall back on a bureaucratic maze that you can use as an excuse for sticking around and waiting for the final decision on your case to come down at the end of time. But unfortunately, the situation in the Catholic Church with its legal system is that it is not, as Dr. Furness said, it's not consistent, not consistently applied, it's not consistently understood.
Mr. Tapsell, can I just return to the question of limitations, which you've mentioned? you've described a position under the 1983 Code, which was a 5-year limitation period from the date of the incident. Now, that was extended to 10 years in 2001, is that right? But up until 2002, there was no discretion on the part of anybody to extend that period, is that right?
That's right. In the United States, the United States bishops negotiated an extension. It took them 6 years, from 1988 until 1994. So in the United States it was different, but in Australia now it was 2010. And then in 2010 it was extended again to 20 years.
So it's now 20 years from the victim's 18th birthday, is that right?
That's right. So they've got to be, if they're over 38, bearing in mind the average age of reporting that's been referred to here. But I accept that now the CDF has an authority to waive that or to extend it indefinitely, basically.
And you may have all heard the data which was referred to in the opening address of Senior Counsel Assisting indicates that on the data available to the Royal Commission, the average time between an incident and a complaint is some 33 years. So it seems as if the average complainant will be out of time and will depend upon the discretion of the CDF. Do any of you have a view about whether that presents a problem still? Sister?
The CDF has the power to disregard that in all cases. It's been granted that power by John Paul II.
But in terms of the exercise of that power, do you have any concerns about whether...
Oh, no, I do not believe that there should be a limitation, a period attached at all, and I believe that also of the state.
I think Dr Austin...
Yes. If it's one of the findings of the Royal Commission from the evidence that has been given to it, that the average age when victims are able to come forward is beyond 30 years of age, then it would seem to me that the statement from the Royal Commission that says, that's what we found, should be followed up by saying, and therefore, in regard to child sexual abuse, leaving aside any other sort of crimes, that in regard to that, a positive statement should be made by the Church that rather than talk about, well, there is a time limit we can waive, the statement, which I'm sure would speak more loudly or more authentically to the victims, will be to say there is no time limit.
We've said that already in the civil space, and a number of states have legislated
yes,
to that.
And that's important.
So what we need to do is to say that in terms of the regulation of statute of limitation, as far as the Church is concerned, for victims of child sexual abuse, there should be none, and that should go from the Royal Commission very clearly to Church authorities.
I noticed the time, Your Honour, if that's convenient.
We'll take the morning adjournment.